So today I'm going to talk to you about the New York Child Victims Act and its impact on independent schools. We'll go over the nuts and bolts of what the law says and then talk a lot about some practical things that schools can do to prepare now before you get an allegation, what to do if you're in the midst of an investigation or responding to an allegation, and then some proactive measures that schools can take in order to prevent, situations like this from arising in the future. So what does the law say? The Child Victims Act was signed into law on February 14th, 2019. And it extends the statute of limitations for a survivor of child sexual abuse in criminal and civil cases in New York. It came into play because there was a lot of advocacy for longer statutes of limitations. It has been recognized that it's very difficult for survivors of child abuse to come forward or even to realize that they had been abused for many, many years after the trauma. And I read somewhere that the average age of someone coming forward is somewhere in their 50s if they've been abused as a child. And so this act is very significant in that it allows, for civil cases, it allows survivors to bring civil lawsuits until they are up to 55 years old, which is a significant extension of the statute of limitations. Under the old law, survivors had a statute of limitations of 5 years from the time they turned 18. So now they can, bring a civil lawsuit until they are 55. Survivors can now also file claims against public and private institutions that may have been involved in the abuse, including schools and churches and clubs and things like that. For criminal cases, it's a little bit different, but does extend the statute of limitations once again. For felony offenses, the age goes up from age 23 to age 28. And for misdemeanor offenses, a survivor can bring a claim. It used to be the age of 20, and now it's the age of 25. Most significantly, the Act created a 1-year, one-time only period to allow victims to seek civil action regardless of how long ago the abuse occurred. So that started, we're already well into that year. It started on August 14th, 2019. And even on the very first day of that act going into effect, New York courts saw over 400 claims filed on that first day. This does not apply to criminal proceedings, so criminal cases that have run the statute of limitations cannot be reopened. But for civil cases, that window is open between August 14th, 2019 until August 13th, 2020. So this means that claims can be filed no matter how old the survivor is, no matter how long ago the abuse took place. Even if the claim had already expired under the old statute of limitations, this is the opportunity to bring a claim. Even if the survivor sued the abuser before and the case was dismissed because it was they had waited too long, it reopens all of those statutes of limitations, and it does away with the previous requirement to file a notice of claim. And so even if a notice of claim was never filed, which was required under the old law, doesn't matter, that claim can be filed within this 1-year window. And New York, waited 6 months to open this window from the time that the act was passed so that courts could prepare for what they anticipated to be this very strong, sort of high numbers of claims being filed. And in fact, they've assigned judges within each court specifically to adjudicate these types of cases. And there are special court rules in place just for these types of cases so that they are adjudicated expeditiously. So what does this mean for independent schools? I mean, I know a lot of you, I've heard from a lot of schools that they lose sleep at night because they just don't know during this 1-year window if they're going to be hit with allegations, a lawsuit, these types of claims, even though they may have happened long ago, are really difficult for schools to manage, especially from a reputational standpoint, from a PR standpoint, and then of course from a legal standpoint. So this does mean that independent schools in New York are subject to these historical claims, and they could even be from decades ago, 60, 70 years. We've seen a lot of survivors contacting schools prior to actually filing a claim. So before they actually file a civil lawsuit, they might go call a school, call the head of school, call a board chair and say, I know that I have my statute of limitations is available to me. I could bring a claim, but I want to talk to you about what you can do for me because of what happened to me when I was a student at your school. And so a lot of conversations are taking place, really settlement negotiations with survivors to find out, what happened, investigating the claim. And then if there is a substantiation, then, talking about what can we do to help so that we can avoid that lawsuit. So even if you don't get the lawsuit, you might get these allegations prior to the claim. And then, of course, New York's law and many other states' laws have, really highlighted this shifting tide across the country and across the independent school industry and across many industries in how schools respond to claims. In the past, we might not have seen as many letters go out, and there might not have been as much transparency in how schools communicate with their community about claims that they receive or allegations that they receive or concerns that they have. And now, with these new statutes of limitations opening up and with just more of a demand from different alumni groups and different advocacy groups and survivors to be more transparent and to do more. We have, every case looks a little bit different, but we have had cases where survivors have come forward in the past and they're coming forward again, and they're saying, what, I'm still not satisfied with how the school responded 15 years ago. And I want to give you another opportunity to address my situation, and what are you going to do? And so schools in many situations are going, erring on the side more of sending out a community letter, asking if anyone knows anything about any concerns of abuse, and really erring on the side of investigating versus not investigating a situation. And we'll talk about what that looks like. So schools should and can prepare and be proactive. Of course, you don't know what's going to come in the next day or the next week, but there are steps that you can take now, if you haven't already, to prepare for the possibility that you might get a potential claim, prepare for the possibility that you'll have to engage in some sort of investigation of a claim, and to take preventative measures against future abuse. So what are some of those proactive strategies before you even get a claim that you could do now, even if you have no reason to believe that, a claim is coming or no issues, but you just never know what happened 30, 40, 50 years ago? What can you do now? We strongly recommend that you assemble a team, both externally and internally, before any type of allegation is even made. This allows the school to have the right people in place so that if you do get an allegation, you can respond quickly and you're not wasting time once an allegation is made, sort of figuring out, oh my gosh, well, what do we do? Who do we call? This is an opportunity to have the right people in place who you can build a relationship with, who you can interview in advance, and who can really get to know the culture of your school, to get to know your stakeholders and your pressure points, because those really do vary from school to school. We do recommend that you have 3 key professionals, and there's different ways to make up these external teams, but you definitely want to have legal counsel engaged and on notice that you're in New York and that you might be subject to one of these claims under the Child Victims Act or other claims. You want to have an investigation firm on retainer. It could either be another law firm. A lot of lawyers do these investigations. It could be, there are also firms that just do investigations. And you want to look for investigators who have previous experience in working with allegations of sexual misconduct and abuse of minors, of students. Those are, as you can imagine, very sensitive conversations, and they really do require a certain level of training and technique that not everybody has. You know, we usually use a firm that has past experience in law enforcement, and they've done thousands of these interviews and investigations, and that, you know, you want that kind of experience so that you have really the right people in place. And then finally, a crisis management firm or a PR firm. We're going to talk about some ways that that can be really helpful, but you know, the reputational harm and just, you know, you're going to get inquiries from media potentially. You don't really want to rely on just personnel within the school to help craft communications, to craft, you know, large letters if there's a report. You want to have someone else, again, who's experienced in dealing with these types of situations, help you draft those documents and come up with the right language and plans in place for making certain communications. You also want to have an internal team, right? So you want to make sure that you have sort of a task force that you designate ahead of time, so that once again, if you do get a claim, we're not looking around to see, okay, well, who's going to deal with this besides the head of school and the board chair? We know who's going to deal with this. We've talked to them about this possibility. We know what might take place next. So, of course, the head of school, your board chair, maybe a member of your school's internal communications team. On this task force, you're going to have your outside legal counsel. If you have in-house legal counsel, you're going to have that person on your task force as well. And then, of course, your public relations and crisis management firm will be part of that task force and part of that endeavor. Additional members within the school that you might include, the school counselor or the psychologist can sometimes be a good person to include on that task force, and then possibly other board members. You know, if you have people on your board, I know a lot of lawyers are on boards, but if you do have some legal expertise, especially someone who is prior law enforcement with criminal experience, or experience dealing with large investigations, that is a good thing to have on your task force, so that, you know, they can bring that experience to bear, even if you have outside external consultants and lawyers working on it with you. Another piece that you can do now is just to locate your insurance policies and figure out what was in place when. This is the kind of thing where, again, you know, we may not have policy numbers and plan documents from long ago, but it would be really good to locate that information. So if you can, you know, look back, look through your files, look for plan documents, policy numbers, any other information related to your insurance coverage throughout the school's history, again, going back, you know, 60, 70 years sometimes. If you're not finding that information, and trust me, a lot of schools are like, I don't have that, I don't know where it is. First of all, don't rely on the insurance company to have the policy, because most insurance companies have a 7-year retention period, and then they destroy everything. So it's going to be, you know, you looking through historical information. You might check with your current broker. They might have information for prior policies. You could check legal files, even if it's for an unrelated matter, because sometimes it might have insurance information on there. Check your board minutes. Sometimes board minutes will talk about insurance plans, policies in place, and past invoices can also be helpful. There are things called insurance archaeologists, so people can have made a living out of finding and tracking insurance policies for you. Some big insurance companies have their own insurance archaeologists, so that is something that's available potentially. I mean, you do have to. It costs money to to engage those folks. So if, maybe you wait until you get the claim to do that, but, it's up to you. It's an option that you have. It's interesting. We've seen a lot of insurance companies, even when we do find the policy and find the related plan, taking very aggressive approaches to limiting exposure to these types of claims. And it's really causing a lot of schools to reevaluate their current policy and look at whether, if later, 10, 15 years later, a claim like this comes up again, what would our policy cover? And we want to make sure that our school is covered. The last thing you can do sort of proactively is just to sort of get the lay of the land in terms of what do you have in terms of employee personnel files and records of past allegations of misconduct that the school has made, reports to CPS or law enforcement. Some schools have a separate file just for those types of reports, which is a really good idea, so that, even if you want to start create a file now, it's a good idea to keep those all in one place, so that if you do get a claim, that there's a central place to look for that information, and you can know whether or not the school made a claim about someone, filed anything. You can look to see whether you have personnel files going back to a certain date and try to locate where those are. So sometimes we talk to schools and they're like, well, we have a big file room off-site. We haven't really been there in a while. Nobody's really looked in it. It's got boxes. We have boxes of files, and maybe take a trip to the file room, maybe see where files are being kept within the school, and see what you have. Just get the lay of the land in terms of what you have in terms of personnel files going back, because that can be really helpful to have if you do an investigation. And then, sort of gather, if you can, institutional knowledge. I mean, sometimes, schools have had the same head for 20, 30 years, and that person alone might have a lot of institutional knowledge about what our risks are, what our potential claims might be. Sometimes you have a brand new head or a really new administration, and they might not have that institutional knowledge. I mean, in some cases, we've seen it's worth, putting out a call to a prior head who's been there for a long time. But it's not a bad idea just to sort of have some behind the scenes conversations with key stakeholders about, okay, were there people that we had prior concerns about? Were there people that, had a certain reputation that we should be aware of? Make sure you have contact information for those prior heads of school, for prior board chairs and prior division heads, because that can become very relevant if we do an investigation. And then look at your alumni database and see if that's up to date. So that's sort of stuff you can do even if you don't get a claim and never get a claim. At least you know what you have in place. If you do receive a claim, of course it's unfortunate, but at least at this point, you should feel like, okay, it happens and let's deal with it. Let's figure out what we can do. The initial steps, of course, if a claim comes to a person who is not the head of school or a board member or a board chair, make sure that you have internal school policies about procedures for bringing concerns that employees receive, or other board members besides the board chair might receive, so that those concerns can be brought to the head of school or to a designated school administrator. And then the first thing you want to do once that information is received is to call a meeting with the council, with your council and with your task force, and sort of figure out, what do we know? What do we need to find out? And first and foremost, just remind all members of the task force of the importance of confidentiality, right? So if your legal counsel is engaged and they're with you, then those communications will be protected by the attorney-client privilege. This is kind of a technicality, but the members of the task force are the holders of the privilege. And so if they make a disclosure, even if it's inadvertent, it could waive that privilege. So it's really important just to reiterate to all those individuals that this is confidential, it's privileged, and disclosing information could waive that privilege. You do probably want counsel to be present for any communications going forward, just to attach that privilege. and also to provide advice and counsel as you move forward. And then to the extent that you have the insurance information, you want to notify the insurance. Another thing you want to do if you get an allegation is to consider your mandatory reporting obligations. Of course, if it's a, it's a situation that's not a historic claim, it's someone who is currently under the age of 18, then you want to make sure that you are reporting it to CPS if it triggers that mandatory reporting obligation. Of course, we know that there was updates to the New York Education Code in 2018 that specifically include educator committed abuse in the mandatory reporting, closing a perceived gap, not really a gap, but there was a perception perhaps in the reporting law that it only applied to parents or guardians, but in fact it always did. And the New York Code specifies now that educator abuse is covered and that we have to report that as well. Disclosures have to be made to the parents under this new code once the school is on notice of a report. Obviously, if it's a historical report, that might not be as important. This is for current reports. And then, reports should be made internally to school administrators first, and then reports go out to CPS. So, a lot of times we have situations where it's not all that clear if a report should be made. And so in some instances, we've put out sort of a blind call to CPS to say, we have a situation, here are the facts, does this need to be reported, does it not? And then sometimes CPS will say, yes, it does, or no, it doesn't. But once again, sort of the changing tide in the industry is to err on the side of reporting. And then those go to a statewide register. And you do want to document the communications that you have with Child Protective Services or law enforcement so that you can say, if something later happens and there's a claim of negligence, that the school did its due diligence, that it reported, that it put this information in front of the agency that could do more with it. Okay. In the next step, there's, you want to, with the help of your legal counsel, decide what to do with the allegation. Are you going to investigate it? Are you not? And then what does that investigation look like? Think about the scope of the investigation, decide whether it's going to be conducted internally or externally. You sometimes want to think about limiting the scope to a specific period of time. Think about whether you want to just investigate adult-on-student abuse claims, or if you're going to include student-on-student abuse claims or bullying claims to the extent that those come up during the investigation. It's really interesting because no two cases are the same. And so, it does require sort of an individual analysis. Sometimes you don't have a specific claim, right? So maybe an employee, a former employee of the school, was named in a report of another school. So these reports come out and then you see, oh, well, this person's been named and that person also worked at our school. And so while we don't have any allegations made against our school, do we have an obligation to investigate? Should we open that window and allow people to air their grievances, if any, so that we know what's out there and what's not out there, and then investigate whatever we find. It's really, a case-by-case assessment, and legal counsel and that task force will really help you in making that, that determination. If there is a decision to conduct an investigation, you want to, figure out how to clearly message the initiation of that investigation and the scope of the investigation to the school community. And again, what that message looks like does vary from case to case. But you do, sort of want to work with your PR firm to develop a communication timeline so that relevant stakeholders, can be notified before sending out a communication to the rest of the community, maybe big donors, your board members, your current employees, parents, so that they're not sort of caught off guard and wondering where did this come from. Okay, so the investigation itself, once again, there's different approaches to how to do an investigation, and hopefully you'll never have to go through this, but if you do, these are just some things to think about. You can do it internally, or you can hire an external investigation firm to do it. Again, sometimes because of the shifting tide and how these claims are perceived and the level of responsiveness that schools, sort of have to rise to, it makes sense to hire a third party to do that investigation for you. Again, it depends on, the seriousness of the allegations. It may not be necessary in every situation, but it does provide that arm's length objective third party to look at something from the outside as opposed to the school looking into it themselves. And then could there be a claim that, well, the school, covered up the information that it found and it didn't follow all the leads because it's trying to protect itself. And so in order to avoid those types of claims, having a third party do it is really a good idea. And of course, that person might be more experienced probably than anyone at the school in conducting investigations. And so you'll have that to your benefit. If you do have an external investigator look at this, you can ask for an investigation plan. You want to enter into an engagement letter, establish the scope of the investigation. We like to keep things sort of open-ended because you just never know when, additional claims might come forward or additional survivors may come forward. So you can build in some flexibility, but just give you an estimate of cost and things like that, of hourly rates and things like that. It's a good idea to have your counsel retain the investigation firm, once again, to just keep it all within that attorney-client privilege. Okay. Communications during the investigation. Work with your PR firm and your counsel to figure out what to say if you decide to issue a letter to the community to say, look, we've got this allegation, or we have this concern, or we're going to do an investigation. You want to balance sort of explaining the reason for the investigation and what's going on versus the confidentiality of the victims, right? So sometimes if you identify a specific person who's been accused of child sexual abuse, that might inadvertently reveal the identity of the victim, because in some of these cases, you go back and you're like, oh yeah, that person was really close with so-and-so, and I bet it was so-and-so. And so when we have survivors who don't want in any way their name to come forward in the investigation, we need to be very, very careful in what we communicate to the community and whether sort of, dots can be connected that might lead to them having to out themselves. You want to describe the general scope of the investigation in that communication. And of course, re-emphasize sort of the school's commitment to safety and protecting students. We want to, communicate, of course, to alumni, especially in these situations with historical claims of child sexual abuse. Once again, that's where having sort of this updated alumni database is really helpful. But if you get bounce backs or emails, sent back, or letters sent back, work with your investigative firm to find more current information and maintain a record of every person to whom a letter was sent. And if you got a bounce back, keep a record of that, because we want to be able to say this person got a letter, this person didn't get a letter. It can be important during an investigation. And then of course, at the conclusion of an investigation, how do we communicate our findings? What do we communicate, and how? Sometimes a situation, merits or really needs a very fulsome report with a lot of detail. Usually that's in situations where alumni have really advocated, or survivors have advocated for transparency and a lot of, feedback, because a lot of people have come forward and it can make sense in some situations. In other situations, if you can provide a shorter summary, that might be sufficient. In any case, the head of school and board chair should prepare a letter to accompany the report. And, not only sort of include, once again, sort of, we did this report, we did this investigation, we want to protect our community. This is how we're going to, you know, prevent this from happening in the future. This is how we respond to allegations and concerns now. If there are remedial measures that are being provided to survivors, you know, you might include some of that in the letter. You know, what are policy changes that we might be making? Are we going to train our employees? If that's the case, I mean, sometimes we've already been doing all that, but it doesn't hurt to sort of reiterate that this is an opportunity to confirm our efforts in this area. And you also want to have a media relations plan in place before any report goes out, because, you know, you might get calls from the media, individual employees might get calls from the media, and you want to make sure that people understand who the points of contact are, right? So you don't necessarily want employees, individual board members, individual staff members talking to the media. You want that person to refer the media to a spokesperson at the school, not your legal counsel. That shouldn't be your spokesperson. We get that question a lot. And, you know, that spokesperson should have a clear strategy, talking points that they've prepared, and you know, sort of manage that relationship. Again, this is where your PR firm comes in really handy. Be prepared that you might receive additional information after a report out happens, because sometimes it just takes that last report for someone to feel like, okay, now is the time I'm going to come forward. So that, you know, sort of talks through what happens if you get an allegation, what you can do, but then what can we do as a school to safeguard our communities now, so that going forward, we, you know that if we get a concern, we're addressing it, that concerns are being brought, you know, to the right place within the school, that we know what our mandatory reporting procedures are. So here are some steps. You know, review your policies regarding sexual abuse and misconduct. You know, first and foremost, you just want to make sure you have a very clear reporting procedure in your employee handbook that applies to all members of the community, that we understand that, you know, we're looking for inappropriate conduct or child sexual abuse that might occur with volunteers, with coaches, with contractors. It doesn't have to be a member, an employee of the school. We want to include procedures for internal reporting, so that, you know, we had a situation once where it was really important that a faculty member brought the concern to the head of school first, and that before we contacted the parents and before we contacted Child Protective Services, we safeguarded that student, because there was a concern that the head of school knew about, that there could be a flight risk or that there could be harm brought to that student, and we could take sort of protective measures before certain communications were made. This sort of internal before external reporting also allows the school to keep records of what was reported. So, right, we now know how hard it is when you go back and you don't have records of what was reported and what was reported to law enforcement, and it looks like, you know, we didn't do our due diligence. Well, now we have the opportunity going forward to make sure that we are creating and keeping really good records about our due diligence, about, you know, what we learned, what we reported, and to who and what date and all of that. Some schools have taken the approach of providing a hotline or an anonymous reporting mechanism, just to make sure that there's absolutely no question that people have a place to go if they have a concern. There's pros and cons to these, which our time doesn't really allow us to go too far into, but it's something that if you feel like there's not clear avenues, then it's another measure that you could take. Your guidelines, your reporting procedures should also ensure that reports are taken very seriously and that they are investigated, and that, you know, it has some procedural language about how the school will respond to a report of child sexual abuse. Another thing that we can obviously do to safeguard our communities is to conduct very thorough background checks on the adults coming into our communities. That includes not only our employees, but of course our coaches, our volunteers, other third parties that are left to interact with our students or to provide supervision over our students. And lastly, training. Training is a huge, huge component of safeguarding our communities. Train your faculty, your staff, your students. We're seeing a lot of student-on-student abuse, which is not, really covered by this act, but it is a huge issue at schools. And so what are we saying to our students? What are we doing to train our students on how to interact with each other? Coaches, summer employees, there's a lot. And if you have a camp, there's a lot of people coming in and out of that off your campus. If you have a pool and you have people using your pool, renting your facilities, think about who's coming onto your campus and where your risks are. And then of course, volunteers. Okay, so that is the presentation in terms of what I prepared, but I know that we wanted to leave time, Marcy, for questions.
I have one question so far in the chat box, Grace. Specifically, somebody asked, can you provide an example of inadvertent disclosure that you've seen or heard? And other people, if you have questions, if you want to put them in the chat box now, that would be good.
Sure. So there are times when this happens a lot more often with board members, because a lot of times they're also parents at the school. And especially if a board member hasn't, been trained in this type of situation, or doesn't otherwise, understand sort of attorney-client privilege, it can happen where sometimes a board member will get a question about, oh, okay, so I got the letter, what's really going on? Can you tell me what's happening? Or asking a question about, well, who is it? Who is it that, raised the concern? Or who is it that it's about? Is it about this person? Is it about that person? And they sort of start to dig. And sometimes a board member will tell another parent something that is confidential, that was only discussed during that task force meeting, which is attorney-client privileged. And so that's the kind of situation where you really want to set forth at the outset that this is confidential, and just remind everybody.